Matt Holder for Appellant Communication Workers of America, AFL-CIO. This case goes to the very heart of fairness under arbitration, where a collective bargaining agreement has a grievance procedure that culminates in binding arbitration. Two central principles to that are that the arbitrator, in rendering an award, cannot rewrite the terms of the collective bargaining agreement, and the arbitrator must afford fundamental fairness and due process to all parties by giving them notice of the issues to be resolved. In the contract that is at issue in this case, the grievance process has two steps that culminate in arbitration, and there is a procedure that allows the union to skip to the next step of the process if there isn't a timely response from the company. In this case, the grievance was fired in January of 2014. A grievance was filed within the time prescribed by the contract, 45 days, in February of 2014. A written decision dismissing the grievance was issued in August of 2015, and that same month the union appealed it to the second step of the process. From there, the union requested information to ascertain the validity of the company's claim that the grievant was a pro performer, which was the grounds for his termination. The information was slow coming from the company. There was a grievance meeting set in February of 2017 that was rescheduled to later in that month, while at the same time a letter confirming that the grievance was in recess was sent to the company. From there, the company failed to provide the information and failed to reschedule the grievance for hearing. The union filed a charge with the National Labor Relations Board to compel the company to meet on the grievance. A complaint was issued by the board, and ultimately the company met with the union in October of 2018. Following that meeting, no written decision was issued by the company as required by the CBA. At that point, the union was decertified and the parties met to resolve the outstanding issues, and this case was one of them. The union proceeded to arbitration in December of 2019. An arbitrator was selected, and she determined through a summary process to evaluate whether or not the asserted defense of laches by the company was legitimate. She ultimately found laches based on her construction of the contract. She took the provision that said the union may, after 2 weeks, skip a step, and said the union has to, within that 2-week period, skip a step or it waives arbitration. Now, peculiarly, she focused on the...
Did the arbitrator actually say if you don't seek arbitration within 2 weeks, you waive it? Is that the basis of what the arbitrator found? I thought it was that the amount of time that had lapsed from that 2-week period was so long that the defense of laches applied.
I think that she kind of conflated the two things, Your Honor. The way the decision reads is that you had 2 weeks to do this, you didn't, so any point after that, you are in default. You're subject to the laches.
So I think that argument might have some purchase if the amount of time we're talking about is 15 days, right? Because then it would be, well, 2 weeks went by and boom, you didn't immediately request arbitration, therefore you waived it, right? But those are not the facts here, right? The 2 weeks went by where a mutually agreeable meeting date was not arranged, right?
Yes, Your
And
Honor.
if that was August, when did that elapse?
I would say that you need to look at it in October of 2018 after the second step grievance meeting, because from the union's perspective, the case is ongoing. There's no point at which there was default. Now, the arbitrator and the district court seized upon the August 2015 first step answer and said, okay, this is where your 2-week period started. But from the perspective of the union, when it is evaluating the case and seeing things move forward, things are happening periodically. There is no point where time just stopped. The case wasn't frozen in August 2015, and in December of 2019, the union came forward and said, let's arbitrate this. things were moving forward, and they moved forward in a manner consistent with how grievances for the union work. The union represents thousands of bargaining unit employees across multiple bargaining units, and it processes hundreds of grievances annually. So this amount of time...
So your entire claim here is, well, not your entire claim, your main claim is that the arbitrator so misread the Section 7 of the CBA that we should overturn the arbitrator's decision, right?
Our claim is that she misread the word may in Section 7 and made it mandatory, and that in doing so, she...
So what does it mean then? Because I'm reading it right here. If, due to the company's actions, a mutually agreeable meeting date is not arranged within 2 weeks of either the company's receipt of the initial notification or the appeal of the grievance, the union may present its original grievance to the next higher level of the formal grievance procedure. What does may mean there?
It gives the union discretion that it can skip to the next step, or it can continue to hold and await the written answer it's entitled to. And that is something else to keep in mind, is that the contract also says that each step of the grievance shall be responded to in writing, and the union is entitled to that written response. The written response is crucial for the union to evaluate the case and to determine if this is meritorious for arbitration or not. The second step meeting is likewise important because that meeting lets the parties exchange their positions on why this grievance is meritorious and why this grievance is not. Without that information, the union cannot assess the viability of the case, and therefore the union decided to press for that second step meeting and response. And
do you disagree that there is a defense of latches with respect to the right to invoke arbitration? Because I thought that was the basis of the arbitrator's decision. Well, latches, you waited too long, right? And it prejudiced the company, and so therefore latches.
I believe
that's an available defense, isn't it?
Yes, other arbitrators have found latches as an available defense. And I think that for an arbitrator to find that, you have to look at the language of the contract. Here, the ability to skip a step is discretionary with the union, and the union was reasonable in waiting for a decision from the company so it could determine whether or not this case was viable for arbitration. So that way it's just not routine, it's just not jumping to a decision. They want to make sure that cases selected to go forward for arbitration have a fair basis in the facts.
I understand the standard of review here. Even if I agreed with you, you wouldn't necessarily win, because we can disagree with the way the arbitrator read Section 7, and it's still within the arbitrator's discretion how to read this contract.
And there's a tension in the law with the line of cases that talk about how the arbitrator cannot reform or rewrite the language of the CBA. And that goes to the interpretation given to May here, because I don't think that is her definition is not consistent with how that word is understood in the context of the contract, where you see a distinction between may and shall.
Would it be reasonable, I know you're focusing on may and shall, would it be a reasonable interpretation of this Section 7 to say, after a certain 2-week period, the union then has the option to present its original grievance to the next higher level? So the option is created at that point. And so that would be a reasonable period to say, all right, if you wait a really long time from the time that you have that option, then at some point, latches is going to kick in because you've waited too long. That's the way I understand the arbitrator's decision. Is that not what the arbitrator decided?
I think that's a fair way to think about how latches applies in arbitration. I think that here, though, again, you have periodic movement within the grievance process such that the union is never on notice that any type of default or that the company will not be responding to it has occurred. So looking at it from the perspective of the union as it's managing its docket here of grievances with the company, they aren't aware that, hey, they're not responding to this. We maybe need to look at this here because, again, there are things happening. They can't say that, hey, this has gone stale. And I don't think that, even a year or two would be a point in time at which to trigger laches. I think that other arbitration decisions have talked about periods of 7 years and things like that. So, and classical laches is around 6 years, 7 years, 10 years.
The basis of your argument isn't that I didn't think it was that not enough time had gone by. I thought it was she misread this to say, if you didn't seek the next step after 2 weeks, you're out.
Yes.
I thought that was your
That
argument.
is the argument.
Not it's 7 years versus 5 years versus 3 years.
That's correct, Your Honor. I was just kind of filling in that gap there. So, but again...
But the fact is, there were other things going on. I mean, the union was taking some action. There was an NLRB charge, a request for information. Weren't there other things going on in connection with this?
Yes, there were. The union did not abandon the grievance at any time. So again, the district court's error here is that it latches on to August of 2015, just as the arbitrator did, and say that, well, this 4-year window is too much time. But that's not the case. The case continued to move forward. Things were happening. There was no point in time at which the union could sit back and say that, hey, things have stalled. We need to proceed to the next step and just fire up arbitration.
And my question is, I guess, more of a practical one, because when it says in Section 7 of the CBA that you may present your original grievance to the next higher level of foreman's grievance procedure, what is that? What's the next highest level?
Well, from the second step, that would be to arbitration. And so what would happen is that the union would sit there, and if there was nothing happening at the second step, then they could proceed to arbitration, even though there was no second step response. And they could point to the language in Section 7 to say, hey, look, we had to move forward here because nothing is happening.
Well, it doesn't say that. It says within if a mutually agreeable meeting date is not arranged within 2 weeks of certain things happening. That's pretty specific, right? If this doesn't happen within 2 weeks, then you may invoke arbitration if you're at the right step, right?
Yes, but I don't think that means that it has to be invoked. I don't think that it then triggers some type of use it or lose it provision there, and I think that that's what the arbitrator
It does say
created.
promptly.
I beg your pardon,
It
Your
does
Honor?
say promptly.
Yes, Your Honor. And that just means that if it's not arranged within the 2 weeks, it is the union's discretion whether or not to skip to the next step.
It doesn't say it can wait as long as it wants. A year, 2 years, 3 years. You have the absolute right to wait as long as you feel you want to.
I wouldn't go that far, and I don't think you need to find that there was no laches here. Again, I think that what defeats laches in this case is the fact that the union is moving the case along. There are things happening, so there's no reason for it to think that things have stalled.
While things are happening, could you have also said, there hasn't been a meeting arranged within 2 weeks, we're going to invoke arbitration?
That would be the union's discretion. It could have done that.
Well, it doesn't, okay. All right, you're saying the union has absolute discretion to say, well, I don't like the way this procedure is going, therefore I'm going to invoke arbitration.
No, I don't think that that is the case at all. If the union feels like that without the meeting being scheduled, that things are not going to proceed anywhere, that is the point in time at which it can elect to proceed to arbitration. And in this case, because things were happening, it was never put on notice that the case had stalled such that taking the drastic step of skipping the second step hearing and the second step answer was necessary in order to preserve its right to arbitrate. And again, the contract says that not only can the arbitrator not change the language, she can only rule upon the issues submitted to her. And the construction theory that she advanced, or actually relied on, wasn't one she advanced by the company, and therefore was not one in which the union had notice in order to respond to.
Did the company argue that arbitration had been invoked too late?
The company asserted laches, yes, Your Honor.
And she decided based on laches?
But she decided laches based upon her construction of Section 7 and the fact that The 2 weeks triggered a mandatory requirement to seek arbitration, and that's contrary to the written language of the CBA.
And just to be clear, for me, in connection with that, is your claim that, one, it was wrong for her to make that decision, but is there some claim that she should have given you notice that she was going to make that decision?
Yes, Your Honor, that if she was going to rely on a contract construction theory not advanced, the rules of the AAA provide her with an avenue to give notice, similar to how with Rule 56, a district
So
court...
she's required to say, this is what I'm going to do before she does it?
She's required to give you notice of the theories she's contemplating before she makes a ruling on them.
Like latches.
In Latches, we had notice of and responded to, but the contract construction claim we did not. Thank you, Your Honors.
All right, thank you, counsel.
Please the court. My name is Arthur Telegen. I represent Thrive, Inc. The vast majority of arbitration awards do not find their way to the federal courts. There are some really brilliant awards that don't find their way to federal court, and there are some really dumb awards that don't find their way to federal court. That's because the process laid out by the Supreme Court in Trilogy, Steelworkers Trilogy, says that the process, the federal labor law will work when parties choose to use arbitration and accept that part of what they've contracted for, because it is a matter of contract, is decisions, both brilliant and dumb. As it happens, this one was not dumb. The arbitrator was faced with a case in which an employee had been discharged several years earlier for not complying with his obligations to sell directory advertising. There have been several steps of progressive discipline, which the union was invited to. There was a first step grievance meeting when apparently the union was fully informed. The employee happened to have been a union steward. There was perhaps some confusion about a second step meeting under a contract that said you should have a meeting within 2 weeks and the union may skip the step. I'm not going to debate at length may versus shall. I will say that each, in the current contract, in the grievance procedure...
I don't know why we have to debate it at all. It doesn't mean shall. It just doesn't. It means they have the option to.
They do. And it uses exactly the same word as used to tell the parties the union, it can go from the first step, it may go to the second step, and either party may seek arbitration. It clearly means you can do it or you can't. Up to you. The union chose not to take this case to arbitration, skipping the step. It waited effectively several years. While it may have been doing other things, but making an information request several months after the grievance procedure should have ended shouldn't slow things down. And there was a proceeding before the NLRB, which was settled. The company admitted no fault. It didn't focus on this case versus any other. The reality was this case was ripe for arbitration several years before the union submitted it to arbitration. And the arbitrator found that it was too old, exactly the issue that had been submitted to her. It is well within that mass of cases that should not find its way to this court. The question about due process. This court has occasionally referred to fundamental fairness. It's not a Fifth Amendment case. The Constitution doesn't apply to contract arbitration. It's a matter of contract. It doesn't apply to the processes as such. Arbitration varies among very elaborate procedures to An arbitrator sits and decides 10 or 15 cases that go to the commissioner of the NFL, gets to decide cases in the course of the grievance procedure, even though he's a pretty interested party, to there's no arbitration at all. There's nothing that requires collective bargaining to have arbitration. The issue submitted to the arbitrator was, did the union wait too long to take this case to arbitration? Both parties focused on the skip step provision, whether it meant that the union had discretion, as the union told the arbitrator, to wait forever, no limits, or did it mean that the union could bring the case to arbitration without waiting for a second step meeting?
I'm not familiar with the mechanics of the arbitration. I assume you file something like a brief with the arbitrator.
In this case, there was briefing, yes, sir.
You file briefing. I mean, this Section 7 that we're all talking about, did Section 7 appear in the briefing?
Oh, sure. And the entire grievance and arbitration procedure appears there, and she read. I mean, what's unusual about this case, what's unique, is all your case law talks about whether the arbitrator actually read the agreement or not, and the parties debate whether, well, maybe he or she read it, maybe they missed this step. This case is unique because the arbitrator is being criticized for reading the agreement. She just read it too strictly for the union's liking. I understand why they're unhappy about that, but there's no case law establishing that you can overturn an arbitration award because the arbitrator read the agreement. That's what she's guilty of doing. I think, unless the court has any questions, I've concluded.
Thank you, Counsel.
Thank you, sir.
Rebuttal.
May it please the court. I think that the court should focus on the fact that there is precedent within this circuit for the proposition that when an arbitrator exceeds the jurisdiction of the arbitrator under the collective bargaining agreement, the court can reverse that decision. And that is the Delta Queen case, the American Airlines case, the Houston Lighting and Power case, and the DuPont case, where arbitrators look at what happened. They say that, well, despite what the contract says, I'm going to impose a lesser penalty. Most of the cases are termination. The Houston Lighting and Power case is a contract interpretation case about a layoff. But in the end, the arbitrator deviated from what the contract said, and the court said that that goes beyond your authority. And for the union, that is key here, because whereas it doesn't say we can wait forever, it also doesn't prescribe an amount of time. What it does say,
2 weeks.
After 2 weeks, then we can.
Oh, look, I'm reading from the arbitrator's decision. The may in Section 7 referred to the fact that the union could make the decision to appeal to the next level within 2 weeks if it so chose. Isn't that that's the way I would read the decision, the section. Isn't that the right way to read it?
I would disagree, because it's imposing on their mandatory that we must, after the 2 weeks, appeal or lose the right to go to arbitration. And that's not what Section 7 says. It provides the union with a way that if the process has defaulted, it's not just stuck in limbo. It can decide to go to arbitration. And in this case, it chose to proceed to try to get the second step hearing and the second step answer, which are things that it values because that allows it to make an informed decision about the viability of the case. Otherwise, we are knee-jerk having to go to arbitration. There was testimony in the companion cases about how it is routine that meetings don't get set within that 2 week period, and that at no point has the company ever said, aha, you've defaulted, no arbitration. And so it goes to the question of notice, that the union just had no reason to suspect that if it relied upon its process, the process established by the collective bargaining agreement, and met the deadlines to appeal through the steps of that process, that it could find itself at fault because it's relying on that process.
I just clarify, we've talked about the language about the union may present, it's not shall present. But you're not arguing that it says the union may present at any time in the future forever? Or are you arguing that?
I'm not arguing that, but it's
Really, the only question is the arbitrator being reasonable in finding latches given the facts of this case? You're not saying,
Yes.
there is a latches issue, the only question is whether it's been properly applied here.
Yes, Your Honor. That, again, there are other arbitrations where laches has been found because of the passage of time. And perhaps
It would have been within the arbitrator's discretion to do something different. You're trying to argue that it was an abuse of discretion, essentially, like beyond the pale that would justify us exercising the relatively rare act of telling an arbitrator they were beyond the pale with respect to this text.
Yes, Your Honor. Again, the arbitrator's authority is bound by the contract. They don't have unlimited authority. They have to apply the language as is. That's key both to the fact that they cannot rewrite the contract and to the notice provision. The
What
contract,
would you have done differently if you'd gotten notice that the arbitrator was going to issue this ruling? What would have happened if you got the notice you contend you were entitled to?
well, after this decision was rendered, the company pressed the arbitrator's decision in the companion cases, and we mustered evidence to respond to it. That again, the practice of the parties was that routinely things were not set within 2 weeks, that it did take years to get to the grievance, to get from the grievance being filed at the first step to arbitration, that there was nothing outside of the norm or nothing that would shock the conscience. Because again, the error of the arbitrator in the district court is that they look at the timeline and they say August 2015.
You remember what I asked you?
What would we have done different?
Right.
Yes, Your Honor, and I'm sorry, I'm taking the long way there. We put in evidence that persuaded one arbitrator that there was no laches, and he rejected the construction rendered by the arbitrator in this case. A second arbitrator as well rejected that finding based upon the arguments and the decision by the second arbitrator. So there was evidence available to us that we could have mustered had we had notice, and we did not have notice.
So you're saying you would have, in response to the arbitrator saying, this is what I'm inclined to do, you would have presented additional evidence to the arbitrator?
Yes, and here
The CBA allows for you to do that.
I beg your pardon?
The CBA allows that you can do that. That you
I
can
would
go to
say that-
arbitration, a decision's pending, the arbitrator has to give you notice, this is the way I'm leaning, and then you can say, hold on a moment, I have more.
I would say yes because of the incorporation of the rules of the AAA. And the rules of the AAA say that the arbitrator can point the parties to positions, arguments, facts that the arbitrator is contemplating and allow the parties to respond. And again, that's why notice is critical for the parties.
Thank you, counsel.
Thank you, Your Honors.
Court will take this matter under advisement, and we're going to call the next case, which is cause number 20.